How's it looking, Jessica?
It's on now.
Okay. All right. Good morning, everyone. This is the Monticello Park Homeowners Association, versus Renarda Harden-Burke. This is 2020 CV 33976. Today is January 20th, 2021. We are all appearing via the Zoom teleconference platform for the hearing in this matter, which we'll discuss in a moment in more detail. But I just wanted to note a couple of things for the record. Number one, again, we are all appearing remotely. Number two, I have put us, you will notice up at the top left of your screen, I have put us on the court's YouTube live stream channel for the purposes of making this hearing accessible to the public, which is our solemn obligation to do. This will allow anyone who would have walked into the back of the courtroom to view these proceedings, and again, fulfills that obligation. Other than that, I think everybody appears on screen and we can introduce ourselves and then get started. I have this down for a motion for summary judgment, but I know we have to talk about the fact that a final order has already been entered. So, Mr. Joseph, you want to just introduce yourself for the record, please?
Yes, Your Honor. Good morning. Richard Joseph, appearing on behalf of Plaintiff Monticello Park.
Okay, thanks. Ms. Gibson?
Catherine Gibson from the Gibson Law Firm, appearing on behalf of Ms. Renarda Harden-Burke.
Okay, and then there's another lady on who's listed as iPad 2. Do you mind introducing yourself?
Hi, Your Honor. My name is Renarda Harden-Burke.
Okay, you are our defendant and you're appearing via Zoom. Okay, I'm going to ask Mr. Joseph to start us off. Just to kind of set the stage, I will note that this matter was filed, and then back in December, I believe, a motion for summary judgment was filed on behalf of the plaintiff. We counted the days up for a response, entered a final judgment, and then learned later, I believe, that and y'all can clarify the exact record, but found out later, I believe, that a response had been filed or was in the process of being filed. So, Mr. Joseph, I guess the first question to you would be whether the plaintiff has any objection to setting aside that judgment, and do we need to hear that matter?
Your Honor, yes, I do object to court setting it aside. Now, I am aware that this is the same term of court in which the judgment was entered, and so as the law provides, the order remains within the breast of the court and can be vacated subject to abuse of discretion. But we do object to the court vacating the order, and we object to the filing, the late filed response. Not only was it filed after after the order was entered, it was also filed a day late under the original deadline, as the court correctly calculated it. I filed a written objection yesterday afternoon, which I don't think yet appears on the record, but I emailed it to Ms. Cummings, and Ms. Gibson has a copy of it as well. Objecting to the filing of the response, and also objecting to the way in which the affidavit was executed. And while I'm at it, I see that this morning defendants submitted some unauthenticated documents for the court to consider as exhibits, and we object to those as well. They don't meet the requirements of the evidence code, and the court should not consider them.
Okay. Well, Mr. Joseph, that may have been your argument, and that was a good one, but I'll let you go ahead and just, if there's anything else you wish to say on the issue of the existing final judgment, go ahead, and then I'm going to let Ms. Gibson respond.
Yes, Your Honor. Thank you, Your Honor. As the court observed, The plaintiff filed this action August 27 to collect delinquent homeowners assessments, including unpaid bills for water consumption. The defendant filed an answer, which was a general denial. On December the 1st, 2020, we served our motion for summary judgment, and it was filed on December the 3rd, appears of record as of December the 3rd. And as the court observed, on that a response was due on January the 4th, none was filed. On January the 5th in the morning, the court entered a final order in judgment granting the motion for summary judgment. And then later that day, the defendant's response appeared. That's January the 5th. On January the 6th, the defendant filed an affidavit to which we object. We would contend that the plaintiff's motion is sufficient to establish a prima facie case entitling the plaintiff to recovery. And that since the defendant's response was late filed, without any permission or extension of time, the court is completely justified and would be justified in leaving the final order judgment in place. The motion we filed is supported by a duly executed affidavit of the property manager attesting to the debt. The law is clear. The defendant must respond with sufficient admissible evidence to rebut a prima facie case. The defendant had not and has not done that. So the final order in judgment would be proper. It's not sufficient to suggest a genuine issue of material fact or to speculate about a genuine issue of material fact, but it must be rebutted with admissible evidence. And as we observed, even with the late filed affidavit or with the affidavit, that affidavit is not sufficient. It was apparently executed not personally, not manually by the defendant, but with a digital signature remotely. And attached to my objection to the affidavit is the governor's executive order allowing the remote execution of affidavits. And it is clear there's nothing in the affidavit that indicates that it met those requirements. The defendant's affidavit is insufficient on an evidentiary basis.
Let me interrupt for just a moment.
Yes.
I don't know where the background noise is coming from, but I'm hearing some background noise. I don't know if that's making it difficult for you.
Yes, hold on, could the court give me just a minute?
Sure, thanks.
Okay, hold on. Thank you, Your Honor.
Okay, thank you.
I'm back. And I'm sorry for that. We're in a rather open office with high ceilings. And when we moved here, I knew that noise would be a problem.
I don't think any of us anticipated that we'd be spending our lives on Zoom.
Right, that's right. So in her affidavit, which again, we contend should not be permitted because the defendant didn't file a timely response, there attached some unauthenticated documents, as well as the defendant's contention that certain payments that she made haven't been credited. But the assertion is not backed up with any documentary evidence of the payments. If a defendant made a payment by check, then the evidence of that payment would be a copy of the paid check. We don't have that. If the defendant made it electronically with a debit or credit card, we don't have authenticated copies of transactions or receipts showing that. It's just the defendant's bare assertion in her improperly executed late filed affidavit. So we think even taking out the fact the court's already entered a judgment, given the state of the record, given the fact that the response is late, the affidavit is late, there is not sufficient evidence to rebut the case, that the court is perfectly justified with its final order and judgment, and that judgment should not be vacated at this point. Now, as Ms. Gibson and I had a conversation yesterday evening, and I say this to the court, so the court is aware. Even if I have a judgment, I've committed to Ms. Gibson that I will review any proof of payments to make sure that we are only collecting what the defendant in fact has not paid. In good faith, I believe we have credited the payments. I think the defendant's assertions are in bad faith for this reason, as I explained to Ms. Gibson. She's claiming credit for full payments that were made electronically by debit or credit card, but a part of that payment amount would have been a service fee. If we had the actual receipt, the court would probably be able to see that, and I would be able to see that. But again, my point is that I, at any time, with or without judgment, am happy to review payments. I believe in good faith we have credited the defendant properly. We've had contacts with the defendant prior to Ms. Gibson being retained, and we've tried to reassure the defendant of that, but we've been unsuccessful in doing that. So thank you, Your Honor.
Okay, and again, Ms. Gibson, I'm going to turn it over to you now, and let me just clarify that what I'm hearing right now is simply whether we should set the final judgment aside and go forward with the summary judgment argument today. So and I'll warn y'all in advance. Now, let me go ahead and hear from Ms. Gibson.
Your Honor, the motion for summary judgment was filed December 3rd, 2020. The deadline fell on a Saturday, which was January 2nd, 2021. So that the deadline, the first business day thereafter was January 4th, 2021. We e-filed the response on January 4th, 2021 at 3:18 p.m. And the clerk rejected the filing and asked us to revise it, which we did. I believe what we did was file the response as one document. The clerk asked that we break it into separate documents. And so we did that and corrected the clerk's comments, and the filing was submitted and accepted on January 5th, 2021. So our filing, the response was timely according to the 30 days. But even if it wasn't, it was one day. And given that we're in a global pandemic, everyone is working remotely. The Georgia Supreme Court emergency order, the 10th Amendment, states that the court should be generous with timing, given that individuals are working remotely at this time. So we're asking that the court would allow the response and consider it timely, and would also allow the affidavit that was filed in support of the response. The affidavit is not due to the court. It's due to the court one day prior to any hearing on a motion for summary judgment. And of course, Ms. Renarda Burke is working remotely, as are our staff, but my paralegal contacted her by video and witnessed and notarized her signature by video for the notary of the affidavit. And Ms. Burke is here on the line. She can testify to any of the documents that we have filed. And the way how the ledger was filed with the complaint was very confusing to myself and my client. And having spoken with opposing counsel yesterday and getting some clarity on the ledger, that is what necessitated our filing of the additional exhibits so that all of the facts could be in front of the court for today's hearing.
Okay. Okay, thanks. So here's what I'd like you to do. And here was the warning I was going to give you earlier, but let me go ahead and do it now. I'd like to, I'm going to reserve ruling on that issue. I'd like to just go ahead and hear the motion for summary judgment and hear the response, and then I'll get an order out to you on everything.
Okay.
Okay, Mr. Joseph, you're up.
Your Honor, I won't take too much more time on the motion summary judgment because I think I hit it in my original remarks. But again, I want to stress that the motion summary judgment supported by the affidavit of the plaintiff's manager made out a prima facie case entitling the plaintiff to recovery. The burden then shifted to the defendant to make a timely response and to present admissible evidence rebutting that case. This has not been done. I'm not going to rehash my arguments about the affidavit, except to say that contrary to defendant's counsel's assertion, the notary public says that the defendant personally appeared before her, and it's obvious that is not Ms. Harden-Burke's original signature. That is not a handwritten signature. You can compare it to the defendant verified her answer, and it's not the same thing. But pre-permitting that question, the defendant's purported affidavit is not supported by authenticated documents. They are her conclusions. Even accepting what she says, paragraph 11 of the affidavit says, "I do not owe what is being claimed in this lawsuit," which is an implicit admission that she is indebted to the plaintiff. And I would say that the defendant simply doesn't know what she owes, despite the evidence that we have submitted in the record. The appellate courts of the state are clear that only admissible evidence can rebut a prima facie case, and that mere conjecture and conclusions are not sufficient. And on that score, I cite the court to Fresh and Fancy Produce versus Brantley, 190 Georgia, Appeal 128. Charles H. Martin Distributing Company versus Bernhardt Furniture Company, 213 Georgia, Appeal 481. And Mimic Motor Company versus Moore, 248 Georgia, Appeals 297. Similarly, the purported exhibits defendant seeks to have the court consider today are not properly authenticated and are not evidence. They are not admissible and should not be considered. And since this is a motion for summary judgment hearing, the affidavit, the evidence should be on affidavits, and defendant testimony should not be considered at this time. Thank you, Your Honor.
Hang on, Mr. Joseph. Let me ask you just a couple of questions.
Yes, Your Honor.
Final judgment notwithstanding, what do you say that the defendant owes your client?
Well, the amount that the court granted in its final order and judgment. That total amount is $10,565.72.
Okay.
That includes the unpaid assessments, including water, interest, court costs, our cost of collection, litigation expenses, and $1,590 for attorney's fees. And in the record is my affidavit authenticating the attorney's fees and expenses and testifying as to the reasonableness and necessity of those costs.
Okay, now let me just break that down. And I apologize, I don't have the final judgment in
Yes,
front
Your
of
Honor.
me for a lot of technical reasons
I understand.
that I'm too embarrassed to state. But the you said that includes the unpaid water,
And assessments.
Unpaid water and assessments, and then court costs, interest, and attorney's fees.
Correct, and our litigation expenses, costs of collection.
Yeah, that's what I was going to ask you about. What
Yes,
what is that as opposed to attorney's fees?
Well, the attorney's fees are for the fee for my work. The litigation expenses are the costs we incurred in prosecuting the lawsuit. That includes everything, everything but the court $214 filing fee court costs, but that would include the expense of service, the e-filing fees, copies, copy expenses, mailing expenses, and the also expenses for prep work that we do before filing a suit, whereby we do reports for bankruptcy and location, and each of those have a cost attached to them. There's an itemized bill attached to my affidavit which details those costs.
Okay. And I guess this is probably not an appropriate legal question, and I'm sure the authority that you cited earlier would deal with this, but can you just tell me about what efforts that you know of were made prior to suit to resolve this matter with the defendant?
Yes, Your Honor. On April 10th of this year, we sent the defendant a letter explaining to her what she owed at that time and letting her know that she could dispute this and to contact us and how she could make payment, and that she should deal with our office, not with our client or our client's manager. Despite the letter, the defendant, in fact, tried to deal with the association and the manager, but we had numerous contacts with her, trying to explain to her what she owed and why she owed it. We have an account representative here in the office who had conversations with the defendant. In August, that's not in the record, but I'll say we also sent a follow-up letter before we filed suit, itemizing what the charges are. Now, during this time, and this is one thing that kind of complicated things, as I said, the defendant attempted to still deal with our client, the management company, and that's where she made the payments, rather than making the payments to us. So sometimes there was some confusion about when payments were made and where they were made, because we would then have to verify them with the client because we didn't have record of them. And if there was any confusion on the defendant's part, that was of her making for insisting on making payments to our client rather than making the payments here at the office, where of course we would be immediately aware of them. But we tried to work all that out. As I said, before we filed suit, I sent a final letter with the itemization of what was owed. And again, that did not come to fruition, and we didn't have settlement there. Even after we filed suit, the defendant continued to make some payments. Again, I state in good faith, I believe we have given her credit for all of those payments. But, you know, at any time, I'm happy to review that. I just don't think now was the appropriate time to do it, given the posture of the litigation.
Okay, thank you.
Thank you, Your Honor.
All right, Ms. Gibson?
Okay, thank you, Your Honor. Ms. Harden-Burke attempted to resolve this matter numerous occasions prior to litigation. She contacted the management company. There's a separate water billing company she contacted. And she also contacted the opposing counsel's firm and was unable to get clarification on the amount owed because it did not make sense to her. The reason is because in April of 2017, and I attached as Exhibit 1 the documents that I filed this morning, her deed, which is when she purchased this property. It's a townhome condominium style location. And in April 2017, she received a water bill at that home for $3,793.94 in someone else's name. It's the same address. She questioned that bill, and we contend that that's the issue that it explains why we're here today. She questioned that bill with the water company and also with the HOA, and it's never been resolved. On the ledger that's attached to the complaint that was filed by Monticello HOA, they are contending that her water bill is $7,037.64 as of September 2020. And this is, again, a townhome community. So she has been fighting this water bill issue for some time. Out of disclosure, I represent 5 or 6 homeowners in another case that's pending, 2020CV339767. One of the issues in that case has to do with the declarant's water bill. So at the time, which is attached as Exhibit 3 to what I filed today, at the time that Ms. Harden-Burke moved into the community, their water bill was $250,000. The declarant has consistently not paid the water bill. The water bill has always been an issue in this community, and 5 of the homeowners have filed suit. About 40 homeowners have sent letters stating, why is the water bill over $400,000 in this community? And why are we paying for the declarant's use of the water and them not fixing water leaks in the community? So that dovetails into this situation. Again, Ms. Harden-Burke moved in April 2017. She received a bill the same month for $3,793.94. And I attached as exhibit number 5, a Roto-Rooter plumbing service sheet that she hired a private plumber to come to her home and check her pipes. And he wrote on the document that the pressure valve was damaged because whenever the builder was building, there was pressure coming in and damaged her pipes. So she had to pay to repair the pipe, but he didn't find any kind of water leak at her home. And that was in 2019. And then I also attached as an exhibit number 6, the water bill that she received in January of 2021. And that shows a balance of $2,448. So the difference on that bill and the ledger is close to $5,000. So the majority of the amount that the HOA is seeking has to do with this water bill that we contend is incorrect. It's been incorrect since day one. And the association is not even paying the water bill themselves. The declarant, who is the builder, tried to leave the community in December with a $400,000 water bill. And that's how we ended up in litigation in the other case. Now, as it relates to her assessments, just the principal balance, Ms. Harden-Burke says in her affidavit that she contacted the management company because she did lose her job in 2018 after she bought her home. And she wanted to catch up in 2019. And the amounts that were on the ledger did not make sense to her. She didn't know where this extra thousands of dollars was coming from. So she calculated for 12 months in 2018, $140 a month. And then 12 months in 2019, $155 because the assessments went up. And then in 2020, she calculated 6 months at $155 a month and made the payment based on her calculations. And then they filed suit in September of 2020. And so she had started making payments. She asked the law firm about, before this motion for summary judgment, she had no idea that that $7,000 was the water bill, because it says specific assessments utility /utility. It doesn't say what that is. And there's another company that collects the water bill. So she did not realize what this $7,000 was on the ledger. And so she paid $3,989.59 through the end of 2020. And we submitted in receipts as an exhibit all of her payments. She also made 2 payments to the water company of $500 each. And we submitted that as well. So we contend that the amount that is sought by Monticello is incorrect. The water bill is not $7,037.64. Ms. Harden-Burke tried her best to get clarity on what she owed. She was told to speak with the law firm. No one explained to her that it was the water bill at all. I just found that out yesterday. And that's how I submitted the exhibits today, just to show that her water bill has consistently been incorrect since she moved in. So we're asking that a question of fact does exist as to the correct amount that she owes. And, you know, Mr. Johnson has made the offer, and I also engage in that as well if I'm representing a client, which is come together with the other side, present your information, I present mine, and we can come to a resolution on at least the principal balance that's owed in this case. But the water bill, we contend there's no way she owes $7,000 water bill. There's no way that she owes $7,000 water bill. So we're asking the court to set aside the order, and that a question of fact does exist as to what the true amount is that she owes.
Okay, let me get some facts from you. And in doing so, I'm going to display my ignorance a little bit because I can't see the documents at this moment. So bear with me. When did she purchase? Is it a townhouse or a condo?
It's a condo styled like a townhouse.
Okay. When did she purchase the condo?
April 2017.
And at the time she purchased the condo, did she know that the water bill was part of the homeowners association fees?
Yes.
Okay. And is it a variable amount? I mean, does the monthly amount of, or how are the fee association dues paid? What period of time?
The association dues are paid monthly. The water bill is sub-metered. So there's a main City of Atlanta meter, and then everyone's pipe has something that they use to measure the water usage for that particular unit. And that data is collected by a third-party water bill company, and they send individual bills to homeowners based on their usage each month.
Okay, so each month she pays the monthly assessment, which you said right now is $155?
Yes.
Okay, and then she's billed a monthly water assessment?
Yes.
Okay, and did that monthly water assessment show an outstanding balance?
In April of 2017, when she moved in, she received a bill from another person, and it had another person's name on it with her address, and it was $3,793.94. And that is what alerted her to an issue with the water. She didn't understand why she was getting someone else's bill, why it had her address on it. And so this water bill has been carrying over all this time. It's never been rectified.
Okay, so I think the answer to my question is yes. the water bill each month contains a past due amount.
Yes.
Okay, and is she directed as part of that process to deal with the third-party water biller? Or is she directed to deal with the homeowners association?
They're pointing the finger back and forth. The third party, there's been 3 water bill companies since she's lived there. They keep switching to third parties. And at one point she was told by the third party water bill company that you shouldn't pay this bill. You should contact the HOA, because if I was you, I wouldn't pay this bill. This is obviously a mistake.
Okay,
So
well, that's hearsay. Okay, so, all right. So this has been an ongoing matter. Is she current on her dues, monthly dues to the HOA?
she would have been current, but what happened was when they filed suit, they accelerated 6 months of payments. So that made her past due. But she is now paid $3,989.59 towards her HOA dues. And I think she would have approximately $1,400 remaining.
Okay. Okay, now, and I'll ask Mr. Joseph this question too when I get back to him, but has the association, to your knowledge, initiated the lien procedure for past due assessments? They have
Oh, you're asking me?
they have a right to pursue a lien against the property. Have they initiated that process? That may be part of the suit, but in which case I'll get back to Mr. Joseph, but from your perspective, have they initiated the lien procedure?
I don't know for sure. I can't answer.
Okay. And then, is this new property, or did she buy this property from a prior owner?
I would have to ask her. I know that these are new development that they were selling. I don't know if she bought a resold one or a brand new one, but they just finished, the association just finished building it out the end of 2020.
Okay, so they were still the declarant. Okay, thanks. I may get back to you, Ms. Gibson. All right, Mr. Joseph, do you want to address any of those questions that I had, and do you want to address Ms. Gibson's argument in general?
Your Honor, not to be repetitive, except to say there is no admissible evidence to any of the arguments. I can confirm this, that the court asked about the lien. When we sent our demand letter in April the 10th, 2020, before we filed suit, we recorded a lien at that time.
Okay.
And the letter informs the property owner, in this case, the defendant, of that fact. Let me just go into a little bit about the water billing situation. As defendant's counsel expressed, there's a third party that handles the reading the meter and doing the billing. But I want to make it clear that money is owed to the association. The money isn't owed to the third party. They're just a collection agent. They read the meter. This is a very common arrangement, among communities. There is a master meter that is with the city of Atlanta, and the city of Atlanta bills the association, and the association has the hope that its homeowners will pay what their meter shows they owe, so that the association can then in turn pay the city of Atlanta. As for much of what else defendant's counsel stated in that area, I'm not familiar with that. I haven't been involved with any dealings between the association and the city of Atlanta. I think that I agree that despite the payments and aside from the water bill, as the defendant admits, there was a time, she says in her purported affidavit, where she didn't pay the association for anything. And I think that is correct. And I think there is still a debt owed even aside from the water. But taking that whole question then, you know, if the defendant acknowledges that she had an obligation to pay water, that she does have an obligation. It's based on metering. It is her actual consumption. The covenant makes the homeowner responsible for the water utilities provided by the association. Yet the defendant didn't make even an effort to file a response. And I think the court has accurately gauged the deadline. I think it's January the 4th until, you know, January the 5th. The two just don't jive. If it would have seemed the defendant would have taken more assertive action sooner in this matter if she had a genuine belief that she didn't know the money she owed. And I say, based on her affidavit and the comments of counsel, I think it's obvious the defendant acknowledges she has a debt. Now, I'm not suggesting the court do this, but I will say this. If the court makes the ruling that the judgment should be vacated, at the very least, liability should be adjudicated and leave damages to another day. Now, I'm not suggesting this or advocating for this, but I just would say that at the very least, in terms of liability, that ought to stay in place and leave only damages for later adjudication.
Let me ask you a question, Mr. Joseph. So if this seems way off point, just humor me. This has nothing to do with how the court might ultimately rule, but is she the first owner to your knowledge?
I think she is not.
Okay.
I think she is not.
Because the essence of her argument seems to be that she inherited a big old water bill. And that either came from the prior owner, or it came from the declarant, or a combination. And I mean, she says, I opened a bill for $3,000 and I was shocked. And you know, everybody's probably been in that water situation at some point, maybe not that high. But so is there any, I guess, under either one of those situations, I guess I think she makes the argument in her response that the declarant unilaterally changed the covenants, but I, that argument notwithstanding, is there any question in your mind but that this bill belongs to this property? Could any of it belong to the declarant?
No, Your Honor. All the billing is based on the metering at that address. And the covenants have a feature called grantee liability, which says that your financial obligations of an owner transfer to your successors in title. And that would be why the defendant in this case would be obligated for a water consumption and billing from a previous owner.
Because presumably, and I'm way outside the lines right now, but presumably there was a closing at some point, and any outstanding amounts probably should have been. I don't know that a closing attorney necessarily checks utilities, but okay.
Well, I'm not an expert on that. I would say this: in the city of Atlanta, an experienced closing attorney probably would.
Okay.
Because this is an aside, as Your Honor knows, if you watch the local news, water billing disputes with the city of Atlanta are well known.
Right. Okay. Okay. Anything else, Mr. Joseph?
No, Your Honor.
Okay. Ordinarily, I would we'd be looking at rebuttal, but we've gone over our time a little bit now. Ms. Gibson, I promised to faithfully read everything, and I promise both of you to faithfully read everything that you submitted either late yesterday or today. I have not done that. And I did not want to put this argument off, so I'm not able to give you an answer right now, but I will do so quickly. Probably reach out to y'all for the actual preparation. And it's nice to meet both of you. And again, I thought everybody did a really good job today, which I appreciate, and we'll get something out to you as soon as possible.
Your Honor, I did have one comment. Ms. Burke is on the call if you wanted to know if she purchased the house new or.
You know, as I said, I was kind of outside the lines there. I was curious about that. I think the legal issues are the legal issues. And again, if we, however this turns out, I promise I can't promise you'll be happy, but I can promise that, we'll try to get it right. Okay. Thank y'all very much.
Thank you.
Everybody have a good day.